So she not going? Yeah, that's right. He did. No, they did. He's all dropping. Oh, Jack. Yeah.
All right, who do we not have now? Let's see. Okay, all right. Now, Christina, now it's warm. I know it's not. Who? Hi. Okay, all right, council's interested parties, we're going to go on the record at this point in time in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 1835572. Mr. Beebe and Mr. Partridge, good afternoon. All right, Mr. Stillwell and Mr. Boston, Mr. Sharp, good afternoon, gentlemen. All right, Mr. Williams and Mr. Steele, good afternoon. All right, Mr. Kendrick and Mr. Weinstein, good afternoon. All right. Mr. Huey and Mr. Matthews Jr., good afternoon, sir. All right, Mr. Nichols and Mr. Westmoreland, Mr. Harvey and Mr. Garner, good afternoon. All right. All right, and Mr. Dorsey is still on trial in front of Judge Adams. Mr. Ryan and Misty Williams. All right. Misty Williams, I understand that you are under the weather at this point in time. My commitment to you is we will take up a few things and we will recess so you can get some recuperation, okay? All right, you're welcome. All right. Ms. Hilton, Mr. Uhelski, and who do we have at the end of the table over there?
This is our legal assistant, Boston.
Okay, Ms. Knight, good afternoon, madam. All right, and in the chief seats, Messrs. Brown and Smith, good afternoon. All right, good afternoon, Mr. Randolph. Okay, all right, okay, all right. All right, we're gonna go ahead and we also have a special guest. I'm just going to acknowledge him for purposes of just for those of you that know that the court does do outreach with other courts. We have a visiting judge from Japan. Sir, what is your? If you could tell the good people here what your name is.
My name is Will Manuiwa from Japan, and I'm a visiting judge.
And what kind of court do you preside in, sir?
Well, I was in jury of civil case and juvenile case.
Okay, all right. So, in our interest of learning about other courts and other cultures, our judge is going to be with us for a little bit to observe and probably see him over the course of the next several months. Okay. All right. Okay. So with that, Mr. Sharp, I believe that we have a few motions for Mr. Stillwell this afternoon. And I believe that I have the motions that I have for you are as follows. I have a motion limiting inadmissible hearsay. I believe we discussed that already. And were you going to particularize the statements that you believe or that you want the court to consider?
I believe what we left it, Your Honor, is Harvey also chimed in on this issue. I believe that we left it that the state was going to identify certain need to admit, and then we were going to battle it out from there as opposed to us just identifying issue after issue. And that's fine with me, Your Honor. I don't need to have that heard today.
All right, Ms. Hilton, madam, when do you all believe you'll be able to identify those statements that you believe that we'll have to address?
If you give us to that September date that you were providing.
September 5?
Yes.
Okay, all right.
If something changed,
Okay. Is that acceptable with you, Mr. Sharp?
It's great to understand.
Okay, all right. Okay, so I'm going to defer that for the time being.
I had the opportunity to speak yesterday about the motion, and we didn't have a proper report to hear.
Oh, that's always dangerous. Okay, all right. I'm listening. Go ahead, Matt.
Mr. Stillwell,
Yes.
we would like to hear today but I'm gonna identify motion number 2, which is a motion for specific discoverable materials.
Estimate, okay, all right.
A legal argument. Also for us to hear motion number 5, which is a motion to suppress defendant's statements. And then 8 and 9, which are the same motion, one just amended, motion to suppress items. For motion number 3 and motion number 7, we have witnesses, but unfortunately, those witnesses did have some prior commitments when you reached out to them for this afternoon.
Okay,
Which are put in 3 and 7. Evidence. The testimony for that motion also relates to Mr. Nichols, who we're hearing tomorrow. So that is a motion that we'll potentially hear tomorrow. I know there's a number of motions for tomorrow that is good to hear tomorrow or later because it doesn't involve Mr. Nichols.
all right.
And then as the motion number 6, I believe Mr. Sharp needs to particularize the motion for us to be able to address that motion.
Do you think you'll have that particularized, Mr. Sharp? Can you do it by the?
Exactly why we have.
Yes, sir. That's the unparticularized. Okay. Whoever told you that is just. All right. Work for me. Come on now. I know. It's a 6. It's a 6. Yeah, it's a 6. It's a 6. That's fine. That is more than fine. Okay, and I believe that's consistent with what I gave out yesterday. All right. Okay. Okay. Let's take up Mr. Sharp, motion number 2, which is a motion for specific discoverable materials.
Thank you, Your Honor, and please record, and I'm going to rename my motion. Motion for specific potential expository material.
If you're going to rename your motion, sir, you probably need to do that in writing. But
Well, I understand.
okay, but will that fall under the umbrella of motion for specific discoverable materials?
Yes.
Okay.
So I specifically asked for rough notes from various law enforcement officers involved in this case. The state has responded. I'm aware of specific case law that indicates that the discovery statute does not necessarily cover rough notes. However, Brandon v. State, which is a case that deals with the discovery and an officer's rough notes, does indicate that they should be turned over if there's another basis for which the defense is legally entitled. My interest in this case, as opposed to the average case, I ask for rough notes often, but in this case, it's particularly imperative to obtain the rough notes, especially regarding the death of Donovan Thomas on January 10th of 2015. Initially, in 2015, Detective Thorpe of the Atlanta Police Department, who was lead investigator on that case, worked that case and sought warrants of 4 individuals on that case for the killing of Donovan Thomas. The state's theory has, and I'll say this also, Detective Thorpe's hand or typed notes and police reports aren't always printed out or compiled in real time, meaning they're summaries of past work that he updates. He seems to update every so often. That presents the opportunity to sanitize notes into a more coherent narrative. In this case, 4 individuals were initially arrested.
But doesn't 1716-4, doesn't it exclude informal notes of law enforcement?
I can agree that the case law indicates that, but
Okay, then why do you want their notes?
well,
These aren't experts, right?
they are not experts.
Okay, all right. So tell me why would I, why are you asking the court to impose an additional burden upon the state
Well,
to do those?
to the extent that the state does not want to hand them over to the defense, I would ask that the state be ordered to hand them over to Your Honor for an in-camera inspection to determine the existence of Brady material in those handwritten rough notes. And the reason is because initially this case, when it was investigated, it led to the arrest of 4 people. Only one of those people is currently charged with said crime, meaning that there's been a change in the state's theory, the change in what the state believes may have happened. And I'm concerned that the police reports do not portray the full investigation and the investigative leads that led initially in other directions.
But isn't there case law which says that they don't have to retain their informal notes?
Well, Your Honor, I don't.
Cited me some case law to that effect. State versus Brown. Reciprocal discovery does not require law enforcement to preserve everything associated with the case, including informal notes.
And Your Honor, I don't know if I don't. The law may not require Detective Thorpe to maintain those notes, but at this point, I have no information to suggest that Detective Thorpe or other individuals involved in the investigation have not retained these notes. And what I'm asking Your Honor to do is to order that the notes be provided to you, Your Honor, for in-camera inspection. And then if there is Brady material that is either points to different leads or provides impeachment materials, then I would ask that we be provided with those materials.
So the state has a duty to turn over those 2 categories of information already, don't they?
Well, I don't know if the state has possession of those notes.
So my question, is the state required to turn over those 2 categories of Brady materials anyways?
They are, but I don't believe, and I could be wrong, but I don't believe they're under a duty to search for Brady material. And I wish,
No, they don't.
I wish to ensure that if there's something out there, it's presented before we try this case.
Aren't you asking me to fish then?
I'm not asking you to fish.
Then okay, then if the statute, excuse me 1 second. If the reciprocal discovery statute 1716 2 covers, doesn't require them to preserve notes, and they're not experts, and they would have a duty to turn over Brady as well as impeachment material. What exactly are you asking the court to do?
I am
asking me to require them to, if they have them, to produce them?
To you, Your Honor. I agree that we should not be allowed to quote unquote fish, meaning the defense attorneys.
Oh, so you want me to fish, Brady?
Well, Your Honor, in situations like this where we have a child, in other cases where we might have a child victim or a victim with mental health issues or things of that nature, the court orders medical records, psychiatric records, etc., to be provided to chambers. And then
there's a specific statutory
I understand.
Exception and requirement for the court to go through a certain protocol. You'd agree?
I understand.
Well, there's no protocol in this particular in Title 17 for me to do this, and so barring some other reason. other than you want to see if there's any additional Brady that the notes may provide you. And you want to see if there's some extra impeachment, or any impeachment, I should say, that might be in there.
Yes, Your Honor.
Okay, anything else?
That is it, Your Honor.
Okay. Who on behalf of the state is going to respond? All right. Mr. Halsey, go right ahead, sir.
Thank you, Your Honor. I'll make this brief. I heard Mr. Sharp mention some rough notes by Detective Thorpe, and I also heard of some rough notes from ADA Sprinkle. And I heard that the name of the motion was retitled to include Brady, but the problem is, as Your Honor is aware, Brady doesn't even require state agents to retain their rough notes in the course of their investigation. That's Hambrick v. State, which is cited in the state's response. That's 175 Georgia Appellate 207-212. And Your Honor is correct, from what I heard, that the reciprocal discovery statute, by its own plain language, doesn't require disclosure of the type requested here when it comes to rough notes, either to the defense or via the court when it's a fishing expedition.
And let me correct myself. You're right. 1716.4 is the reciprocal discovery statute. 1716.2 is the attorney work product.
Which, Your Honor, in the applicability section says specifically, and this goes to Sprinkle's notes, which were just discussed, work product is privileged and it's explicitly excluded by statute. So under Georgia law, and you'll notice that I didn't see any case law statute cited in the motion itself. I didn't hear any cases cited other than the one that we cited to Your Honor in our response, Brandon v. State, which outlines the fact that neither Brady nor discovery requires disclosure such as that requested here, Your Honor.
All right.
I would respectfully disagree. Brady does require disclosure of exculpatory material. The question is essentially to what extent does the state, and I'm asking Your Honor to take an active role in this, to what extent are they required to find exculpatory material? And Your Honor, we don't have an answer about whether there are rough notes or not. And all I'm seeking is if we could determine if there's rough notes, and if there are rough notes, if we could determine if there's Brady material. And if the state said, as officers of the court, we've looked at all the rough notes and there's no Brady material, then I guess I would be stuck with that answer. But I don't believe anyone's made any efforts to inquire about rough notes, and Your Honor, without even looking at the notes, I don't know how anyone could determine if there's any Brady material or not.
Okay, but what you're asking me to direct the state to do is to inquire as to whether or not they have rough notes. They don't have any rough, that Brady nor 1716.4 require that. I mean, for rough notes, unless they are experts or fall into a different category. So, and I mean, I believe, Mr. Shard, as well, that the continuing obligation that the state of Georgia has, as well as you have well, the state in particular, for Brady material at any point in time on the continuum is ongoing. So if they unearth something that might be, or come across it while they're doing their prep for this court, this case, they'd have to turn it over to you. But I'm not going to necessarily require them to go and look at their rough notes, agents' rough notes. So I'm going to deny your motion. But I will remind the state, as I would remind everyone who's opted in reciprocal discovery, you have a continuing obligation to supplement. You have a continuing obligation to turn over Brady and any other impeachment material, regardless of asked. So, Mr. Yahelski, if you'll go ahead and prepare a suitable order, you can send that to Mr. Shart and I'll look at it, okay?
That's agreeable. Thank you, Your Honor.
If you could have that done by the 5th, does that work for you?
That's more than enough. Thank you.
Okay, all right, thank you, sir. All right, what's next, Ms. Hilton?
Yes, Your Honor, we have the motion to suppress the defendant's statement.
All right, is that argument?
We have evidence, Your Honor.
I'm sorry?
Yes.
Okay.
Motion to suppress the defendant's statements.
Okay, all right.
And Your Honor, Investigator Flores is coming in. A portion of the testimony in this case, Your Honor, involves testimony from our April 17th hearing involving Officer McCure. This is in continuation of that testimony that was provided, I believe it was either April 17th or April 19th.
Yes, ma'am. Thank you. What's the name of your witness, madam?
Nico Flores.
Nico,
Yes.
officer?
Investigator.
Okay. Investigator Flores, can you do me a favor? Can you please stand, sir? And State's Deputy Ingram, be sworn as witness, please.
Swear firm testimony you give the truth, whole truth, nothing but the truth.
Yes.
Have a seat. State, spell your first and last name for the court, please.
Nico Flores, NICO FLORES,
And Investigator Flores, where are you currently employed?
Atlanta Police Department,
And how long have you been with the Atlanta Police Department?
since 2015.
And if you could tell the judge about your current role with the Atlanta Police Department.
I'm a detective in the gangs unit
And how long have you been with the gang unit?
since late 2019.
And with the gang unit, do you work on a particular shift?
Yes.
What shift is that?
The daytime between 10 and 6 p.m.
10 a.m. and 6 p.m.?
Yes.
And how long have you been on that shift?
Since 2019, since I got in the gang unit.
Now, do you also operate in the gang unit in an on-call manner?
Yes.
If you can tell the judge a little about what do you do as an on-call detective with the gang unit?
Excuse me. We typically, after hours, work hours between 10 after 6 p.m., where we get requested by the zone supervisor to come out and investigate suspected gang criminal activity.
And you said that sometimes you'll be requested to look at suspected gang activity. What type of crimes are you responding to, and what would make a gang investigator have to respond to a location?
Homicides, aggravated assaults, robberies, house shootings in particularly. We do respond to house shootings a lot.
And why is that you respond to house shooting?
Because our supervisors believe that just not a typical ordinary individual's house would get shot up just for no reason. So it's suspected that it's possible criminal gang activity.
Okay. Now, when you respond to a scene, say a shooting, what will you do when you arrive on the scene?
We'll speak to the supervisor and the first time scene to get briefed on, what took place when they first got there and what witnesses or victims said.
And do you at times speak to victims or witnesses on the scene?
Yes.
All right. I want to take you back to March 16, 2022. Were you still in this position of a gang investigator with the Atlanta Police Department?
Yes.
And did you have the occasion to respond to 2830 Waters Road, Atlanta, Georgia?
Yes.
If you could tell the judge, what was the weather like that evening?
It was nighttime. It was dark and rainy.
About what time do you recall responding to the scene?
About 2:30
Is that 2:30 a.m.?
p.m. Yeah, a.m. Yes, a.m. Sorry.
A.m. in the morning?
Yes,
All right. Was it dark outside?
yes,
All right. And were you on call?
yes.
Why did you respond to that location?
By the request of Sergeant Suazo, the Zone 3 supervisor, overnight supervisor.
And what happened once you arrived?
I spoke to Sergeant Suazo. He briefed me on what took place when he first arrived.
And what information did you have when you arrived on the scene?
Basis.
Your Honor, we are in a motion hearing, and some of this testimony was already given back in April of 2017. I mean, April 17th, 2023.
All right. Any exception, madam? Here says a lot of preliminary hearings, but
Effect on a listener, what he did once he responded.
all right, I'll allow that. I'll allow that. Okay.
Once you arrived on the scene, what information were you given, and what did you do in response to that?
Sergeant Suazo advised me that they responded to a house shooting on Waters, and when they arrived, they attempted to make contact with any individuals on the inside. They knocked at the door, nobody came. But while looking through the window, they seen a foot, which in fear of anybody inside hurt or injured, they made forced entry, and they located some individuals on the inside.
Once you had that information, what did you do?
I asked Supervisor Suazo who was the individual on the inside and where they at.
And did he provide that information to you?
Yes.
Once he provided that information, who was on the inside and where they were, what did you do?
At that time, he advised me there was one individual on the inside because they didn't have nowhere to seat him, and the rest of the individuals were in a patrol vehicle.
Do you recall who was the one person that was inside?
Yes, Cavante Battle.
Now, specific to this incident, did you end up speaking with an individual by the name of Shannon Stillwell?
Yes, briefly.
Okay. Where was this individual when you spoke with him?
In the back of a patrol car.
And when you went to go speak with him in the back of the patrol car, can you describe how he was seated in the car once you went to the vehicle?
He was basically slouched backward into the chair. Yeah, he would like slouch backward into a chair, like on his side, basically. He was detained at the time in handcuffs. Basically, I just got his demographics, first, last name, date of birth.
And when you were out there, what was your understanding of the individuals who were detained? Were they under arrest?
No, they weren't under arrest.
What was your understanding of the individuals who were out there on the scene that day?
That they were victims of a house shooting that they were inside.
Now, when you responded out there as a gang investigator, did any other gang investigators respond out to the scene?
Yes. Investigator Dabney with the Atlanta Police Department and investigator Marissa Viverito.
And at the time, where was the investigator Viverito working?
At the Fulton County DA's office.
Now, did you record or have your interaction with Mr. Stillwell recorded?
Yes.
Have you had an opportunity to listen to that recording?
Yes.
Y'all have permission to approach?
Yes, ma'am, you may.
show me what's been marked as State's Exhibit number 15. Tell me if you recognize State's Exhibit 15.
Yes,
How do you recognize it?
that's my initial with the date.
And what's contained on State's Exhibit number 15?
Stillwell statements
Okay.
on March 16, 2022.
Say it again.
Oh, Stillwell statement, March 16, 2022.
And have you had an opportunity to listen to those statements?
Yes,
And are those statements a complete, an accurate depiction of the statements that you made to Mr. Stillwell on March 16, 2022?
correct.
Were there any additions or deletions?
No,
Your Honor, this time the state would like to tender for the purpose of this hearing, State's Exhibit number 15.
Any objection to States 15, sir? All right, States 15 is admitted and may be published as you see fit for purposes of this hearing. Is it an audio hearing?
It is on.
Okay, all right.
Mr. Can we have permission to share?
Do you have to ask me a letter?
While we're waiting, once you spoke with Mr. Stillwell, to your understanding, was Mr. Stillwell ever arrested for the incidents or anything that occurred on March 16, 2022?
no,
And to your knowledge, was he free to leave that evening?
yes,
Commissioner Prince, you Your Honor,
You may, madam.
I'm gonna show you what's going on in State's Exhibit number 4. Do you recognize State's Exhibit number 4?
yes, ma'am.
How do you recognize State's Exhibit number 4?
That's Shannon Jackson.
Is that on the night of March 16, 2022?
Yes, ma'am.
Is that how you found him in the car when you went to go speak with Mr. Stillwell?
Yes, ma'am.
Your Honor, this time state like Tennessee Exhibit number 4 is evidence.
Any objection to States 4? States 4 is admitted for purposes of motion. May be published as you see fit. I see it, please. Thank you.
Right, we're gonna, since we can't share it right now, we're gonna try to do it just using our wireless speaker.
Okay.
What y'all got going on? Right, when you got there, it's like.
Can we put it next to a microphone, maybe? Maybe it'll pick up. Everything will pick up.
Are we able to share it?
I think you might be able to now. Mr. Kearns went upstairs to see if we could get it done, get that done.
Your Honor, we can publish this. Your Honor, we can publish.
Um, I'm sorry?
We can publish this to the next witness.
All right. Okay, that's fine.
Hopefully, you know, share it.
Mr. Kearns went upstairs to see if he could get that taken care of.
After, speaking with Mr. Stillwell, and speaking with any other individual that could be involved in this.
Yes.
Cross.
Please court. Good afternoon, sir.
Hi, how you doing, sir?
Investigative court.
Yes.
My name is Matt Charlotte, I represent Gene Still.
Nice to meet you.
Nice to meet you. Couple questions. First, do you read a report concerning your involvement in this case?
No. I didn't write a report, no. I said, no, I didn't write a report.
Now, you saw a medical journal.
Yes, you may. Here you go.
Showing you State's Exhibit 4. I know that you indicated that you knew what that picture was. What is that picture?
It's a picture of Shannon Jackson
Okay, where is Shannon Jackson in that picture?
in the rear of a patrol vehicle.
Okay, and are his hands free to move?
No, like I said earlier, he was in handcuffs.
Okay, so in that picture, he is in here.
Correct.
In that picture.
Correct.
Now, who placed him in that control?
Responding officers.
Okay, so you did not place him.
No.
Did he, to your knowledge, did he choose to add police?
I'm not sure. I wasn't there.
To your knowledge, did he choose to be handcuffed?
Excuse me?
Did he choose to be handcuffed?
I'm not sure. I wasn't there.
So you weren't there for the placing of Mr. Stillwell in handcuffs and placing him in the back of the patrol. Is that fair?
That's fair.
Do you not understand what time did this shooting occur?
I responded about 2:30. So anywhere between 1:30 and 2:30.
Well, okay,
Approximate time, I'm not sure. I just got to call it about 2:30, and I got there about 2:30. Look, I got the call before 2:30, and I arrived at about 2:30.
okay, so I'm going to ask you to be a little bit more specific.
Mm-hmm.
As specific as you can. you're saying that you arrived at approximately 2 p.m.
Correct.
and you received a call when?
Maybe about 2 p.m. 2 a.m. Sorry, 2 a.m.
Okay. And was your understanding that you received the call after the individuals had been located in the house?
Correct.
Okay. So by 2 p.m., the people that were in the house had already been located, taken out of the house by other officers.
Correct.
We don't know how long before 2 p.m.
No,
Or
no.
2 a.m.
Yeah, I don't know.
Is it fair to say that your understanding, Mr. Stillwell had been discovered by police for at least 30 minutes by the time you
That's fair to say.
it could have been longer.
Yeah, it's possible.
Did you take that picture
Yes.
with your cell phone?
Yeah, my city issued cell phone at that time.
Is that how you recorded the interview as well?
Correct.
And what time specifically did you take the statement?
I don't remember the specific time.
How many statements did you take from individuals? I mean, how many individuals did you speak to as far as non-law enforcement?
6.
And do you remember the order of those 6 individuals?
It was Cavante Battle, Miles Farley, Demikion Garlington, Shannon Jackson, Cortez Arnold, and Craig White was the last one.
And for purposes of the record, can you say Shannon Jackson or Shannon Still?
Yes, we have aliases on.
So you arrived at, and you also spoke to law enforcement before you spoke to any individuals, correct?
Correct.
So you spoke to law enforcement and then at least 3 other individuals before Mr. Jackson, correct?
Correct.
Right, and those other interviews, how long would you say that interview with Mr. Jackson or Mr. Stillwell?
Not long at all, less than, on my part, less than 30 seconds, but just recorded. Yeah, my interaction with him like less than 30 seconds.
Were some of the other individuals, some of the other interviews with the other individuals,
Longer than 30 seconds? Nah, maybe Miles Farley, but
he spoke for a longer period of time, correct?
yeah, longer than 30 seconds.
Where were Mr. Stillwell's personal belongings at the time he was in the state?
I'm not sure where they were.
And do you know I may have asked you this, but I'm going to ask you this case. Do you know the exact time that he did the statement, Mr. Stillwell?
No, I don't know the exact time.
And prior to taking the statement from Mr. Stillwell, did you Mirandize Mr. Stillwell?
No.
Have you met Mr. Stillwell before?
Not personally, no, but I investigated some incidents.
Have you ever dealt with him as an individual person?
No.
I say you have no living
May we permanently or temporarily excuse Officer Flores, Investigator Flores?
One quick question. Why didn't you?
He wasn't under arrest.
And it is for me to decide that, but
Still.
yeah, it's not your motion, but but yes, I will take that in the proper context. All right, may we permanently or temporarily excuse him?
We can, permanently.
For the purpose of the motion, so we were able to get Mr. Kearns the yeah.
Yes, it should be said.
Okay, all right. Sir, I'm going to go ahead and permanently excuse you as a witness for this particular purpose of motion. Just stay in touch with the state. Don't discuss your testimony with anybody except the attorneys in this case, okay?
Okay.
All right, thank you, sir.
I appreciate it. Thank you.
All right. All right. You have another witness, madam?
Yes, Your Honor, we'll call investigator Marissa Viverito to the stand. Hey, Your Honor, investigator Viverito has testimony related to both this motion and the next motion. Can you just keep her on the stand?
Let's just deal with this right now. I think I'm going to separate as soon as we're done with this witness. We're probably going to complete. It's, as I promised Mr. Williams, we're going to cut it short, okay?
Yes.
All right. All right, madam, if you could approach the witness stand. Once you get there, turn and face Deputy Ingram, be sworn as a witness, please.
Raise your hand. You swear affirm testimony to give the truth, the whole truth, and nothing but the truth.
I do.
Have a seat. State and spell your first and last name for the courts, please.
My name is Marissa Viverito. That's MARISSAVIVERITO.
And good afternoon.
Good afternoon.
Where are you currently employed?
I'm currently employed by the Atlanta Police Department
And how long have you been with the Atlanta Police Department?
since February of this year.
And what do you do for the Atlanta Police Department?
My position is actually the first of its kind for the Atlanta Police Department. Under Chief Sherbaum, it's what's called an investigative gang analyst. So it's a hybrid between a gang detective and an intelligence analyst, kind of focus on complex multi-defendant gang cases.
And prior to your current role at APD, where were you working?
The Fulton County District Attorney's Office
And how long were you with the Fulton County District Attorney's Office?
since May of 2021.
And what were your job duties and responsibilities?
When I first started, I was a senior investigator in the gang unit, and then I became a lieutenant with the high-profile case unit.
Okay. Now, during your time, let me ask you this: prior to working at the Fulton County District Attorney's Office, what were some of your other positions?
I was assigned to the GBI Gang Task Force as an investigator. I'd also previously been assigned to the Atlanta Police Department's APEX unit, which stands for Atlanta Proactive Enforcement and Interdiction, where we would work on what's called VRO targets, violent repeat offenders. And I was also a security threat group coordinator for the Department of Community Supervision with probation and parole.
Okay. Now, during all of your work experiences, and as your time as an investigator with the Fulton County District Attorney's Office, in any of your other roles, did you have the case to investigate the organization or enterprise known as Young Slime Life or YSL?
I did.
And when did you first start investigating or becoming familiar with this organization?
I became familiar with it probably around 2013 or 2014. Back when, in the beginning stages, I wasn't like extremely familiar with it, but because I had a good understanding of the 30 Deep Criminal Street Gang, that's how I became familiar with them.
Okay. And based on your God bless you, familiar with Young Slime Life, did you come to know about any rivalries with Young Slime Life and any other criminal organizations?
Yes.
Who?
The YFN Criminal Street Gang.
All right. And when did that rivalry begin?
From my understanding, like, I was not in Atlanta for when it kicked off originally, but around 2015, late 2014, around then.
Now, taking you to early 2022, were there any events or incidents that showcased the rivalry between the YFN gang and YSL?
Yes.
Okay. If you can briefly tell the court some of the incidents that occurred in early 2022.
So starting in February 22, Rayshawn, YFN Lucci Bennett, was stabbed at the jail. He was attacked inside the jail. And on March 11th of 2022, two members of YSL, Christian McMiller and Darius Ford, were brutally murdered on the highway here in Atlanta. And then shortly after that happened, I don't even think it was 24 hours, the 12 Atlanta grocery store in Summerhill, which is a stronghold for YFN, was shot up, and a gentleman who's an associate of YFN was shot in the head. Shortly thereafter that, there was shootings involving some of the defendants here today on Cleveland Avenue. And then there was a murder of a gentleman named Shamel Drinks that occurred over on Windsor Street in Mechanicsville.
What was the date of the murder, Shamel Drinks?
I believe it was the late hours of March 14th. So I think the evidence processing led into March 15th.
Okay.
And then following that, there was a drive-by shooting that took place at 2830 Waters Road.
And when was that drive-by shooting?
Around between midnight and 1 a.m. on March 16th.
Now, between March 14th, the murder of Shamel Drinks, and on March 16th, the shooting at Waters Road, were you aware, first when Mr. Shamel Drinks at the time, if he was affiliated with YFN on March 14th?
So when the murder first occurred, and I heard the name and I saw a photo, I did not recognize him as somebody I knew to be associated with YFN.
And in the early morning hours of March 16th, between 12 o'clock and 1 o'clock a.m., at this point in time, were there any suspects to the murder of Shamel Drinks on March 14th?
No.
I want to take you now to focus on March 16, 2022, excuse me. Were you working at the Fulton County District Attorney's Office during that time?
I was.
And did you have the occasion to respond to that shooting at 2830 Waters Road on March 16, 2022?
I did.
Why did you respond to that location?
I responded to that location because I was the affiant on a wiretap that was occurring on two separate phone lines that involved YSL members. And I was kind of the point of contact for YSL at that point in time. And we knew that there was a conflict going on. We were trying to get to the bottom of it so nobody else would get hurt. So they reached out to me and said, hey, this is what's going on. You might want to come out and try and see if you can help us out here.
And let me ask, is that 2830 Waters Road, is that in Fulton County?
It is.
Okay. And what was significant about Waters Road, given that you were on this wiretap? Why would you need to respond to the Waters Road location?
Waters Road is a known YSL stronghold or trap house, if you want to call it that, where narcotics are sold. It's frequented by several high-ranking and other members of YSL.
Okay. And when you responded, about what time did you respond to that location?
I was one of the last ones to show up, so probably I want to say between 2:30 and 3, somewhere around there. It was super late.
And did you respond with anyone?
Yes, and but I didn't have a work car at the time, so investigator Dabney had came and picked me up and brought me out there.
When you arrived, what did you find once you arrived at the location?
When I arrived, I can't remember who I met with. It was raining pretty hard that night, so it was like a lot going on. I spoke with one of the officers on scene, and it was explained to me that they had several victims out there. It was a drive-by shooting. Nobody wants to talk to anybody. And I just saw several police cars, and they had the scene under control at that point.
And you said they told you there were several victims out there.
Correct.
Were you familiar with any of the victims that were out on the scene?
I was familiar with Mr. Demekion Garrington and Mr. Shannon Stillwell or Stillwell Jackson.
Okay. And did you know anyone else who was out there?
I recognized Mr. Farley, but I wasn't familiar with him to where I'd have a rapport with him.
And at this point in time, you were familiar with Mr. Garlington and Mr. Stillwell. How long had you known Mr. Garlington and Mr. Stillwell?
I want to say since at least 2013.
For both?
I believe so. I know Mr. Stillwell definitely. I can't remember 100% about Mr. Garlington.
And what happened once you got there and you realized you knew two of the individuals? Did you speak with Mr. Garlington?
I briefly spoke with Mr. Garlington and Mr. Stillwell because those are the two that like I said, had a rapport with.
What was your purpose of speaking with Mr. Stillwell?
To figure out what is going on. That this is because from the wiretap, I had knowledge that they had been either shot at or involved in been victims of some kind of shooting on Cleveland Avenue the day before. And also I knew that two of their very good friends had been murdered. So there was a concern that maybe they were being targeted, and we were focused on conflict mitigation at that point and trying to put out the fire and just kind of see what had happened, or see if they knew who was after them or what was going on, and we didn't get very far.
All right. And when you spoke with Mr. Jackson, where was he? Or Stillwell Jackson, where was he?
In a patrol car.
Okay. And was he handcuffed?
I believe so, but I don't know. I'm not sure if I was aware of that at the time.
And did he speak with you?
He did.
Was it voluntary when he spoke with you?
It was.
Basis. Y'all sustain the objection.
Did he speak with you?
He did.
And have you had the opportunity to listen to that call today?
I have.
You have permission to approach?
Yes, ma'am, you may.
Sure, it was already been admitted, Stacy Exhibit number 15. Tell me if you recognize Stacy Exhibit 15.
Yes, and those are my initials.
Okay. And is this the statement that you that recorded your interaction with Mr. Stillwell on
Correct.
March 16th? Charlotte Publish.
You may, madam.
What kind of car you got? What kind of car you get out? White car. White car.
You don't know. What do y'all got going on that somebody would shoot you? Well, you told her they started shooting. Right, but when you got here, they started shooting. So you didn't see police. Huh. You don't know. You have no idea what's going on. Whose house is this? Oh. Are you gonna run that silver car?
What kind of car you get out?
Now, and listen, some of it was kind of mumbled. Was Mr. Stillwell able to provide you any information that would help you in figuring out who may have shot at the home on March 16th?
No.
Outside of Mr. Garlington and Mr. Stillwell, did you speak with anyone else?
Outside of law enforcement, no.
While you all were out there, did anyone get any search warrants to search the home or anything like that nature?
No, they were victims. We didn't have any reason to get a search warrant at that point for anything.
Now, to your knowledge, was there anyone ever arrested, or was Mr. Stillwell ever arrested on March 16th for what happened at Waters Road?
No, he was not to my knowledge.
Now, at the time when you, again, responded to that scene, was there any indication of anyone in that house being involved in the murder of Shamel Drinks?
No, and I had not even spoken to anybody. Like I said, I was running that wiretap, so I was like living in the wire room. So I had not spoken to anybody about that case or had a chance to even learn the facts really about that case from a detective or anybody else that would have suspect information.
At what point did you get more details about the murder of Shamel Drinks, or what we'll call the murder of Shamel Drinks?
So after I left Waters Road, I went home, went to sleep, came to work the next day, and I stopped by the homicide office to actually speak with Detective Kevin Leon Packer. I stopped by Kevin's desk he was helping me with something. And it just so happens that Detective Hogan sits in front of Detective Leon Packer. And Detective Hogan is great. Whenever he has a case, I always volunteer if he needs help with anything, especially when it comes to gang stuff, because he will ask for help with stuff like that. So I said, hey, Hogan, I know one of your cases may have like a gang component from some of the social media I've seen. Do you need any help? And Hogan was like, he's like, I'm just stuck. I have these 3 suspects in this car. He's like, maybe you can look at the video and help me out. So I sat there for a minute while he pulled it up. And then that's when he pulled up the video and showed me these clips from his video, and which featured 3 males and a vehicle.
So it was after you responded to the March 16th shooting at Waters Road that you learned about any further detail about the homicide of Shamel Drinks?
Correct.
Okay. As relates to solely for the purpose of this hearing, speaking with Mr. Jackson, was it only this interaction that we heard on the audio today?
Correct.
I have no further questions.
Cross.
Good afternoon, Investigator Viverito.
Good afternoon.
Just to be clear, you spoke of meeting with Detective Hogan and looking at a video. That was a video of just gentlemen at a gas station, correct?
Correct. There was a surveillance video from both the interior, I think, and exterior of a gas station. Yes.
Right. So it was not a video of a crime being committed.
No.
Okay. So you said that at this time you were employed by the district attorney's office at the time that this interaction with Mr. Stillwell occurred?
Correct.
Okay. And could you give me your title one more time with the DA's office?
When this happened?
Yes.
I was a senior investigator in the gang unit.
Senior investigator with gang unit. All as a senior investigator with the gang unit, you were tasked to go to scenes of suspected gang-related crimes, correct?
No.
That day, did you not?
That day I did as part of, APD had asked me to come out for, if, that's not a task, basically from the DA's office, we'll go out to homicide things, scenes, things of that, sorry, with the DA's office, we'll go out to homicide things and scenes of that nature. If we are requested by another agency to come out, then we will, but that's not like a day-to-day thing.
As senior investigator of the gang unit, you also have access to gang databases with the DA's office?
No, we didn't have a gang database at that time.
There was no gang database.
Not with the DA's office. I don't believe I didn't have access to one. I would reach out to the Atlanta Police Department for their investigative files, but they don't have a gang database.
Okay, so you had access to investigator files regarding suspected gang members?
Well, I want to be clear on what we're talking about. So I have access to, or I would request people to get me information from their investigative. So the gang investigative files are a completely different system than their reporting system. So for like homicide reports or investigator case notes, I don't have access to that now.
Okay, well, what about the gang system?
At that time, no, I would have to call the gang unit and say, hey, do you have any information on this person or this? I didn't have access.
Did you maintain communication with the gang unit?
Yes, I work with them daily.
And when we're saying the gang unit, we're talking about the APD gang unit?
Correct.
And would that be Investigator Dennis, Investigator Gaither?
Well, they've since retired, so they're not there.
Who are the individuals you're speaking about?
I was working with Detective Flores, Detective Dabney, Detective Underwood. I'm trying to think who else was up there at that time. Those are the main ones I would work with at that time.
And you were also, at that time, primarily listening in on a wiretap of a suspected YSL associate, correct?
Correct.
Okay, and
Two.
Suspected YSL associates. And when I say that you were listening in, you actually did the listening in some of the time, correct?
Correct. We ran a 24-hour double wiretap, and the wiretap room always had to be attended to. So we had 3 shifts that would run 24 hours a day. So I would pick a shift during the day, and then sometimes I would do 2 shifts to help out. But there was always somebody in there. I would occasionally work a shift.
Were you in charge of that wiretap? Meaning, did the other people that were listening in your off time, did they report back to you with reports or anything of that nature?
I wouldn't say in charge. I was the affiant, and I would update like daily reports about things that are going on or what they could listen out for, or try to help people, because some people didn't know, like, they don't know this group as well as I do, or Kim or Underwood or other people do. So I would speak with them daily. So I would stop by the room daily at least, or stop by the office daily, but I wouldn't say they'd report to me every day. They'd call me if they had questions or things of that nature.
You were kept abreast of things that were heard or not heard on the wiretap?
Correct.
Okay. All right. So I'm going to go back to March 14th. As the senior investigator of the gang unit in the Fulton County District Attorney's Office, you had no knowledge of Shamal drinks before March 14th, correct?
No, and I'm going to correct you about the senior investigator. I think everybody in the gang unit that it's like a rank was a senior investigator. So it's like you're not an entry level investigator, you're a more seasoned investigator. Shamal drinks, and speaking with his family, it sounds like he began hanging out with the YFN guys somewhat around, I think they had given us the time frame of Super Bowl, that those were not his original friends, that he had just started maybe hanging out with those guys a few months prior to this all happening.
So I just want to be clear. These conversations with family occurred after his death?
Correct.
Okay. So at the time of his death, you had no knowledge of Shamal drinks?
Correct. Once I was told that Shamal Drinks had died, the name didn't sound familiar to me, which I have a pretty decent memory. I didn't realize him to be a person that was associated with YFN.
At the time?
At the time.
And also, at the time of March 16th of 2022, you, as the affiant of the wiretap had not heard any relevant information about Jamal Drink's murder on the wiretap.
I don't know. I can't tell you when we started hearing bits and pieces on the wiretap, but as far as like when the murder happened and the day or so following, I didn't hear it. And then nobody had reported to me. I checked in with the monitors and nobody had reported it. I didn't hear anything about it. So we didn't think there was anything wrong.
Now, is it fair to say that the Waters Road shooting on March 16th, well, let me ask you this first. Was there a prior shooting of the Waters Road house
Yes.
earlier that month? And what date did that occur?
I want to say on the 13th.
It was before the Jamal Drinks shooting?
I'm not sure if it's the 13th or 14th. I believe prior to, yes. It was prior to, I can't give you the exact date. I believe the 13th.
To your knowledge, has anyone determined who committed either of those shooting acts to the Waters Road house?
I don't know if we've determined, but I think there are some investigative leads that lead me to believe who may have been responsible.
Who is that person?
I mean, there are some NIBIN leads, but they're undetermined as to who the party would be. In my opinion, I mean, shell casings match scene of Christian McMillan and Darius Ford's homicide. So it would be whoever was associated with that incident.
And no one has been charged with any of those incidents?
Not yet. It's still an open case.
So is it, to your understanding, is it fair to say that the shooting of the Waters Road house on March 16th occurred at approximately 12:08 a.m.?
It could have. I want to say I got there between 2 and 3. So that's around the time frame, I guess.
Okay. And I believe that you indicated on direct that you arrived between 2:30 and 3 o'clock.
Around then, yes.
Okay. And you spoke to law enforcement first?
Correct.
And when you arrived, to your understanding, you didn't place handcuffs on Mr. Stillwell, did you?
No.
Okay. And was Mr. Stillwell already in handcuffs when you arrived?
Everybody was separated in patrol cars. It was very dark. Like I said, I couldn't really see who was in cuffs or who wasn't in cuffs. I just knew, I was told they were all victims at that point. That's when I tried to, based on my dealings with Shannon and Demikian, maybe approach them and just say, hey, like, reach out, like, what is going on? Like, we can't continue like this.
Okay, so was Shannon isolated he was by himself in the police car?
Correct. They were all separated.
Okay.
Separate cars.
And he was in handcuffs?
Correct.
Do you know the exact time that you began asking Mr. Stillwell questions?
I know it was raining pretty hard that night. I was exhausted, so I got it right when I got there. I spoke to law enforcement. Like I said, I think maybe, I can't remember who I spoke with. They kept saying they're all victims. There's drive-by shooting. Nobody's being cooperative at this point. So it was shortly after I arrived. I don't know the exact time.
Was Mr. Stillwell present when those officers told you that they're all victims?
He was in the car, but I don't know what had happened prior to me arriving.
Okay, so when you say he was in the car, he was not present for that conversation
Right.
that you're speaking of?
Correct.
Okay. With other law enforcement?
Correct.
And did you Mirandize Mr.
No.
Stillwell?
Anything else?
I think that's it. Thank you.
All right. Any redirect?
Just briefly, when you first arrived on the scene, do you recall if they had found shell casings on the scene?
I think there were numerous shell casings on the scene,
We say numerous, what do you mean?
like several. It's my understanding that there were several shell casings on the scene.
Thank you so much. No further questions.
Anything further? All right, may Investigator Viverito be permanently or temporarily excused for purpose of motion?
Permanent excuse for the purpose of this motion.
Okay, madam, we're going to permanently excuse you for the purpose of this motion. You're free to go about your usual duties and avocation. Just don't discuss your testimony with anybody except the attorneys in this case, okay? All right, thank you, madam. state have any further witnesses?
Not
For the purpose of the motion, do you rest?
Yes, Your Honor.
Okay. Any evidence or witnesses for purpose of motion? All right. You rest, sir? Okay, argument this time.
State reserve argument.
All right, go right ahead, sir.
Your Honor, there's a few things that are undisputed regarding this case or this statement.
Okay, what statement was actually made?
My understanding is and I understand that the sound isn't the best here.
It's not. Because I'm still trying to figure out what statement was made.
Mr. Stillwell puts himself at the house at the time of the shooting. I believe he says he ran into the house and he says that he arrived in a white car that was in the front yard.
Okay, all right.
And so, Your Honor, the things that I don't believe are disputed are Mr. Stillwell gave a statement that night. Mr. Stillwell gave that statement while sitting in the back of a police car. Mr. Stillwell was in handcuffs at the time he gave that statement, and Mr. Stillwell was not Mirandized.
He was a witness, though, wasn't he?
Well, that's for you to determine, but typically.
Well, no, I mean, that's what was testified to.
Well, I'd like to think.
Witness, he wasn't a suspect, because a suspect would require Miranda at that point in time. So, isn't that the distinction?
The label, but the label that the police put on someone is not what answers the legal question. The question is, from an objective person, Mr. Stillwell's place, would he view himself as being free to leave? I would hope that if I was victimized in Fulton County, the police, their first move would not be to handcuff me and put me in the back of a police car. That is odd. That is irregular. And I don't know why he was placed in the handcuffs. If he's not a suspect, I don't know why he was placed in the back of a police car, isolated from everyone else. If he was not a suspect. And Your Honor, I asked about the timing of this. I think it's clear that Mr. Stillwell, from the testimony today, we don't have a definitive timeline. People did not write reports, but I think it's clear that this was not just a momentary placing of Mr. Stillwell in the back of the police car. Mr. Stillwell, from the evidence, I believe it indicates that Mr. Stillwell was in the car for approximately 2 hours. And he's there in handcuffs.
I don't think it was 2 hours, maybe 30 minutes or something.
Well, I don't think, I think, with all due respect, I think we're being, if we say 30 minutes, we're being overly kind to the police because.
Well, that's what investigator Flores said during his testimony. So
he said
where did you get the 2 hours?
He said he arrived 30 minutes after being called, and he was called at an unknown amount of time after Mr. Stillwell was placed in the police
So how
car.
do we know he was in the police car for 2 hours,
Well,
as you're proffered to me?
Well, Officer McCure previously testified. I do not have the transcript in front of me. I am going by the timing of his report, which I believe he testified to the time of the shooting previously. His report says it occurred at 12:08 a.m. We've heard Investigator Viverito indicate that she arrived between 2:30 and 3 o'clock. So maybe I'm being too kind by saying 2 hours, but he was in the back of the car for a significant amount of time.
So you tell
The
me.
question-
So you tell me I'm supposed to look at the objective facts that this is an interrogation, basically.
To determine custody and whether Miranda is required.
Let's just tally the circumstances.
It's an objective standard applied. The question being whether a reasonable person in the defendant's situation would have believed that he was physically deprived of freedom of action in a significant way. The State v. Brandon, 222 Georgia Appeals 372, 1996. I don't know what could be more deprivation of freedom of action than being placed in the back of a police car, isolated and in handcuffs. He's clearly not free to go. And I assert that he was placed there for a significant amount of time. That's not how quote unquote victims or witnesses are typically treated. And he should have, and I'm not, saying that they can't do these things. All I'm saying is, if you're going to treat a victim or a witness this way, and you want to get a statement from them, at least Mirandize them first. That's all I'm saying.
Well, that would go against all the circumstances where the police just need to get information from somebody and they need to determine, well, what's going on with a particular circumstance. It doesn't look like your client was identified by law enforcement as a suspect at that time, correct?
Well, I'm going to say that
You answer my question.
relevant,
Answer my question. Was he identified as a suspect at that point?
I can't speak to what the officers thought, but I don't believe I don't believe that there's been testimony that they viewed him as a suspect, but they treated him as a suspect. And that's what matters, because it's from his point of view, the objective person in his point of view, and I believe it's very reasonable.
Well, I mean, I have some concern about being in the back of a police car, handcuffed to the back, as a victim. So,
Okay, thank you.
so I'm going to ask the state about that, because that's something that bothers me. Because if you truly were a victim in this case, well, you might be in the back of a police car, but you certainly wouldn't be handcuffed, unless it's for officer safety. I didn't hear any testimony about that, mind you, but and I'm not going to assume that, but it does bother me that looking at the objective facts that he's in the back of a police car, handcuffed.
Okay,
as a
thank you,
victim.
Judge.
Okay.
That's my argument.
All right, Ms. Hilton.
Thank you, Your Honor. Your Honor, as I stated when I first started, the testimony involving Officer McCure from April 17th is going to give the answer that the court was just seeking. When Officer McCure testified, I want to bring us back to some context, is that this was a shooting that occurred at 12 o'clock in the morning, where there were over 40 plus shell casings found outside of the home.
I remember that.
And so when Officer McCure testified, he did testify that the reason why all these individuals were detained was for officer safety, because they were trying to investigate what occurred at the home.
Okay.
And that at the time, Your Honor, Mr. Stillwell, along with Mr. Garlington, I believe Craig White, they were hiding behind the home when they first got to the house. And so when they first started knocking on the door, no one came to the door. They sat out there for a while trying to determine what was happening because of the number of shell cases that were outside, in addition to seeing indication of projectiles hitting the home. And so once they started,
I remember that, because photos were introduced of the defects in the home. So I recall all that.
Correct, Your Honor. And Your Honor, I know that, Mr. Shark is saying, the law is very clear on this case. And the state I want to cite or bring the court's attention to, Your Honor, is Haney v. State, which is 365 Georgia Appeal 22, which is a 2022 case. I do have a copy for the court. May I approach?
Okay.
And I have a copy for the defense counsel as well.
All right, well, I understand what Haney says, but, and my question to you is, a reasonable person, okay, in the back of a police car with handcuffs in the back, wouldn't you think that I'm in custody?
No, Your Honor, and Haney speaks
Why not?
to this issue, Your Honor. In sufficiently dangerous circumstances, which the state argued this was a sufficiently dangerous circumstance, given that there was a shooting inside of a home in which 46 shell casings were, 40 plus shell casings were found on the scene. At the time, none of the individuals were being cooperative. The officers did not know what to expect. When individuals are hiding behind the home, coming outside of bushes, lying inside of a house, acting and playing dead, the officers did not know what to expect. And the first set of individuals that were found was Mr. Stillwell, Mr. White, and Mr. Garlington. And so when they were detained as part of an investigatory detention. And because of what they were doing out there, trying to find out what happened, that would not rise to a level of an arrest, Your Honor. And that's what Haney says very clearly. In sufficiently dangerous circumstances, officers may handcuff a person as part of an investigatory detention without transforming the detention to a de facto arrest. The defendant in Haney was handcuffed for purposes of officer safety after law enforcement officers had just heard shots fired on the property, but Haney was explicitly told at the time that he was not under arrest and the handcuffs were for both officer safety and his home. In this case, Officer McClure repeatedly told each of these individuals they are not under arrest and that we are detaining you all for officer safety. And as soon as we finish the investigation, you will be let go. And every last one of them were let go. Even someone who had an arrest warrant was let go on this particular incident, Your Honor. And we have other cases that speak about the length of time, Your Honor. I want to direct the court's attention to Smith v. States, which is 281 Georgia 185, in which in that case, they actually cite an 11th Circuit case, which is United States v. Gill. And in that case, Ms. Gill was detained for approximately 75 minutes and placed in handcuffs in a police car. And the court said that was not, that did not rise to the level of an arrest, Your Honor. So the state's position is, although Mr. Stillwell was detained in the back of a car, again, it was for officer safety, for them to determine what was happening at the time, for them to do an investigatory search, for them to investigate what was going on, what was happening with the crime. And after they determined that they were victims, every last individual was released to go home or to leave the home. And Miranda is only to be administered with someone who is in custody by formally being arrested or restrained to the degree associated with a formal arrest. That's just not what the case is here.
All right.
And so, Your Honor, based upon the Haney case, also looking at Smith v. State, which speaks to the United States v. Gill, Your Honor, the state would ask that you deny the motion to suppress.
All right. Okay, the court, I'm going to utilize as well the court's recollection of the earlier testimony as it relates to the, from Investigator McClure earlier this particular year in relation to the shooting at Waters Road on the 16th of March of 2022 in Fulton County. Originally, Officer McClure did testify that there was a shooting at this particular address. There were a number of shell casings found on or near the location, many defects in the home itself, which the court, in fact, saw pictures of it, and then also defects in vehicles outside the residence at that point in time. Officers at that point in time did, in fact, make contact with various individuals, to include Mr. Stillwell. Believe that they were Mr. Still was found near the crawl space with another individual, and so from there the investigation in terms of, as was testified to earlier, as to what happened was undertaken at that point in time. Mr. Stillwell specifically, since he's a subject and has brought this motion, specifically was separated and segregated and put in the back of a police car for the purposes of officer safety, which in fact Officer McClure did in fact testify to in an earlier session of court, and made certain statements. The statements that were made to McClure as well as to Investigator Flores, Investigator Viverito, and are contained within States 15. The recording made on March the 16th were taken, and of course the court has to determine whether or not the defendant was in custody for purposes of the application of Miranda. Miranda, as we all know, and Mr. Stillwell was placed in the back of a police vehicle for officer safety, as I mentioned earlier, and he was told he was being secured only to ensure the safety of everyone at the residence, and he identified him. It was learned that Stillwell was a victim of the shooting, and the officers agreed. The state's assertion is that a reasonable person in Stillwell's position would not have felt that he was under arrest at any point in time, in the date in question. And that's what the court has to resolve. If the statements made by Stillwell which he made to officers in responding to the shooting would be admissible if Miranda is not required. The court is of the opinion that in looking at the totality of circumstances and looks at the defendant is not in custody entitled to Miranda when he's only being questioned by the police and not a suspect in the case, and that's Mosley versus the state, 269 Georgia 17 pinpoint 20 1998. And he wasn't a suspect of the shooting of the Waters Road residents. The case under investigation when he spoke to the police on the 16th of March of 2022. Therefore, Miranda would not be applicable in the circumstances, even though he was in fact segregated, even though he was placed in handcuffs. He was in the back of a police car. He was in for officer safety at that point in time. So given also the state's application of Haney versus the state, 365 Georgia appeals at 24/2022. Insufficiently, our court of appeals explains in sufficiently dangerous circumstances, which we believe this would occur. You have a shooting of a home and residence, over 40 shell casings, shooting of many vehicles. People on scene. In this particular case, officers may handcuff a person as part of an investigatory detention without transferring or transforming the detention into a de facto arrest. And in this particular circumstance, that's what the court is of the opinion. Under the circumstances of the case at hand, this court finds that a reasonable person would not have felt that he or she was under formal arrest at that point. As a result, any statements given by Mr. Stillwell made at that time were admissible in the absence of any Miranda warnings. So that is the decision of the state, of the court. Ms. Hilton, if you would prepare a suitable order for the court's consideration, you can send that to Mr. Sharp. And if you could get that done by the 5th of September. Is that possible, ma'am?
Yes.
Okay. All right. Consistent with my earlier, statement, since one of your colleagues is not feeling hot, and given that it's almost 3:20, I think we're gonna, conclude for the day at this point in time. So Mr. Sharp and Ms. Hilton, we'll go ahead and continue, and Mr. Sharp will take up, let me just make sure I have all the, what happens when you have a lot of pieces of paper. Okay, Mr. Sharp. And Ms. Hilton, I'll go ahead and I'm gonna continue, the motion to suppress out of court and in court statement says you'll need witnesses for that. You'll need witnesses, as you told me, for the motion to suppress fruits of illegal detention and search. The unparticularized motion to suppress wiretap should be done, Mr. Sharp, before the 6th of September. And is 8 motion to suppress item C's, is that related to your other motion to suppress the fruits? And then is the amended motion to suppress also related, sir, to that one, the original motion filed to suppress?
There's a motion to suppress, evidence, not from the, Overt Act, Fire Act, then the amended, there's another motion to suppress that was amended regarding.
Okay, you got one with Mr. Nichols. You got several motions to suppress. You have one with Mr. Nichols, and I believe that we'll take that up with if the witness is available tomorrow. You've got another one. You got a motion to suppress the fruits of illegal detention and search. That needs witnesses. You've got another motion to suppress item C's, and you've got another motion, amended motion to suppress item C's.
So the second motion to suppress, we began to hear evidence, then we stopped.
Which one is that one?
Motion to suppress fruits of illegal detention.
Okay. Okay, so we need to, that needs a witness. We need to continue the witnesses that was,
So it was 2 witnesses. We heard from one witness, Officer Ledesma, and then we needed to hear from a second witness, Kenneth, who's now with the sheriff's department.
okay. All right, so we'll have to call witnesses on that one. What about, and is that a motion to suppress item C's? What is that one? Is that gonna require evidence?
That's up to the state.
Yes, we have 2 witnesses for an application.
Okay, so you need witnesses on that. And then there's another one, an amended motion to suppress item C. Is that the same?
The amended is related to the one we just discussed, items.
The phone. The phone. Okay. All right. So we'll just, now that I know you need witnesses, depending upon what happens with our other matter that's pending, I'll schedule you accordingly. I'll give you plenty of notice, so, okay, Mr. Sharp? And Miss Hilton as well, all right?
Thank you, Your Honor.
Okay. All right, folks, tomorrow, Wednesday, the 23rd, Mr. Harvey, are you prepared to go forward with your motions, or as many as we can handle tomorrow?
We'll say yes or no.
Okay.
Videos that I asked the state about with regards to motions to suppress 17
I'm sorry, those would be what? I'm sorry? Yes, sir. Is that March 17, 2022? Okay, all right. Yes, sir. Yes, sir.
There is a Jackson General hearing.
Yes, sir. Okay, I mean, you all can update me accordingly in the morning, and we can kind of just, like, much like we've done the past couple of days, just kind of start with, and just make sure that we cover what, and exhaust to the point we can with those particular motions, okay? All right, so tomorrow we'll start at 10:00. So if you all could be here for 9:30, that would be great. We'll start at 10 o'clock and move forward accordingly as the day allows us. All right. Okay. Any other ministerial inquiry of me? Anybody? Anything on behalf of anybody? Any other defendant? Okay. Then I'll see everybody tomorrow morning at 9:30 for an anticipated 10 o'clock start time. And Mr. Mr. Harvey, and we'll go ahead and, as I said, we'll take stock in the morning. You and the state can kind of brief me or update me on what you want to cover. Okay. All right. Okay. We're in recess then. All right. Thank you.
I think it was April 17th. April 17th, I have the second. I think all of them are all April 17th before.
Yo, it's your boy Marita boy back up in this thing, man. Listen. So what we watching here, we're watching the YSL motions hearings. This looks like a motion to suppress hearing. I've had a couple of them in my time. Actually, I won a motion to suppress once. Motion to suppress. I had a weed charge. They found the weed out my pocket, y'all. Swear to God, they got the weed out my pocket. And I went to court. I had my lawyer file a motion to suppress, and I actually won the motion to suppress. They threw the weed out, and I walked out the courtroom like Tupac, swinging my arms back and forth like George Jefferson. You know what I'm talking about? Like, y'all can't hold me. Y'all can't hold me down. You know what I'm saying? So I understand how a motion to suppress hearing works. And if you don't know what a motion to suppress hearing is, a motion to suppress hearing is when the police have evidence on you, you can file a motion to suppress hearing to get the evidence thrown out. Now, your lawyer got to come up with a reason why they want the evidence thrown out. In my case, the evidence was the weed, the marijuana. And how my lawyer argued that they should throw the evidence out is that my lawyer argued that it was an illegal search and seizure, that they didn't have the right to stop me. And the judge agreed. And they threw the marijuana out. And that, therefore, with no evidence, the case was dismissed. A motion to suppress hearing happens before the trial. Let me explain something to y'all. If any of you guys are ever caught doing any crime, I advise you to get file for a most suppressed hearing automatically. Anyway, I don't care. I don't care what it is, because you might have a chance of beating the case before it even go to trial. You see what I'm saying? Like, I always file for motion to suppress hearings. I don't care what case I ever had. It's automatically most suppressed hearing. You know what I mean? Because a lot of times the police may do things wrong, obtain evidence wrong, and you can beat the case. You know what I'm saying? That's how Spoon That's how Spoon got off his charge. They illegally searched the phone. They illegally obtained the phone. Therefore, any evidence that was in the phone, the pictures, were thrown out. That's how he got off his case. A motion to suppress hearing. The paperwork on my community wall, if y'all want to go check it out, just scroll down my community wall and you can see it's in black and white. But yeah, so that's how a motion to suppress hearing works. Now let's get into what I heard in this hearing today. So if you pay attention, it was about 5 YSL members in there. There are 5 different attorneys. They were all sat at different tables around the courtroom. I don't know why they kept showing that one guy over there to the whatever, left, right, whatever. But Young Thug and all the rest of them was in there too. And they were sitting at different tables with their different attorneys. What I overheard today was the things that stuck out to me, the things that highlighted to me, is they had a wiretap on 2 YSL members for a long time. They had 24-hour wiretaps running 24 hours. And they had 3 shifts running to listen to those wiretaps. Boy, that's a lot, boy. 3 shifts listening to you every day, every second, every phone call. Jesus. Also, one other thing that stuck out to me, they had gang task force monitoring them. Atlanta gang task force monitoring them, and they were chronicling every incident of violence that happened between YSL and YFN. I mean, everyone, even down to when Lucci got stabbed in jail. You know what I mean? And I didn't know it was this many alleged murders between these 2 factions. Like, like they're tying a bunch of murders. Like the shooting incident where they were talking about when Mr. Stillwater and them was there. And Stillwater was the guy that they kept showing on screen. The co-defendant that was on screen, the YSL member that was on screen. They say the bullet shells from that incident matched bullet shells from another incident that had a double murder at that incident. So, man, these guys really were going to war, allegedly. That's exactly what the state is saying. That's crazy. Like while we sitting here watching Young Thug and Lucci them do videos, and Lucci dropping a song with PNB Rock every day we lit, and Young Thug dropping all these hits and radio jams and all of this, you know, in the Atlanta streets. It's World War III between these 2 factions, man. Damn. That's crazy, yo. You know what I'm saying? I mean, it don't surprise me, because what we see going on nowadays with these rappers and stuff like this. But this is crazy. I want to say this too. I'm gonna get out in front of this, but I think we know where this is going. Let me tell y'all something. We're going to look back on this time in hip hop as probably the most violent time ever in hip hop history. Ever. When this smoke settles and these rappers either crash out, get killed, or one or the other, or go to jail for a long time for like RICOs and stuff like this here. Because these 3 situations are probably the most likely outcome for a lot of these guys that's indulging in these activities. You know what I'm saying? We're gonna look back on this time as the most violent time in hip hop, and we are losing and are going to lose some of the most talented rappers, artists uh, of this generation, one way or the other. This is what's going to happen here. This is what's happening. Um, I watched a video yesterday where hip hop is changing. Um, I think Ebro came out and said it. Record companies now are tired of these rappers. But I said this. I said this before. When I said that they're gonna clean up this drill culture, because I think that what's gonna happen, these record labels gonna start getting sued for the things that these rappers are doing. Such in the Melly case, the mothers of Sack Chaser and Juvie are suing Young Thug, 300, 100K Track, more, all the what do you call it, Fredo Bang, and all of the entities involved. And I think what's gonna happen is, once the record companies see that it's a liability to be signing these guys, but it got to be about money. Other than that, they're gonna, they'll keep signing them. I think they're gonna stop signing them because of the money. They're gonna be losing more money or be found legally liable. Okay, so I watched the video yesterday where now what's happening with the record companies, they're signing international talent now. It's a big thing about signing international talent, because international talent, they can market them to multiple on multiple fronts, and it's not a lot of violence surrounding them. They were talking about Bad Bunny. They were talking about a couple of Nigerian artists. They were talking about it's a Mexican artist, Mexican guy. I forgot the name of it. Even Dr. Dre and Eminem just signed an Asian guy. But yeah, so hip hop is changing. What they're doing is, that's why you see the rappers' numbers going down. That's why you see the rappers not selling as much no more. That's why you see Meek Mills and a lot of those rappers complaining and stuff like that. The record labels are shifting away from these drill rappers, and switching to signing international rappers and international artists. And I'm gonna tell you another thing about it too. Some of the international artists are using some of the American artists, how I'm gonna say, style, but it's not as violent. It's not as violent. It's not a lot of violence around it. Like they were saying, like these rappers nowadays with the drill rap, you can't even put their songs on commercials. You can't even put their songs on ESPN or something like that. So what they're doing is they're moving away from these violent drill rappers, and they going across seas. They say Lotto is on 2 songs with 2 international artists. One of them went #1. I forgot what the artist's name is, but one of them #1. And they say that is what's going on here. They switching away from the drill rappers slowly but surely. They letting them kill each other off. They suck it. They whooping them when it comes to the contracts. And there's, behind closed doors, is a new wave of international artists that are coming to a radio near you. Yeah, but back to the YSL case, what we just heard here. Yeah, these guys were warned in the streets of Atlanta, man. You know what I mean? And today it was a motions hearing, a motion to suppress hearing. From what I heard, the judge, whatever Mr. Stillwell said when he was in the back of that police car, I didn't hear what he said. Maybe you guys heard what he said. You can jump in the chat and let me know. But whatever he said, his lawyer felt like it was incriminating. So his lawyer was trying to get whatever statement that Mr. Stillwell, which is a YSL member, one of the Young Thugs co-defendants, made in the back of that police car that evening. We were trying to get it thrown out. The judge did not agree. The judge deemed that it was looked like a scene of a shooting, and Mr. Stillwell and a couple more individuals were hiding and looking like they couldn't discern whether they were victims or whether they were suspects. That the police were within right to detain them in back of a police car for an extended period of time until they were able to decipher whether they were victims or suspects. And Stillwell's lawyer was trying to argue that the police treated them like suspects. But the judge deemed that no, the police just didn't know whether they were victims or suspects, so they had to detain them until they were to determine which one they were. But anyway, I'm gonna do another video real shortly here. I just wanted to give you guys an update on the YSL case. We haven't covered the YSL case that much on this channel, but we're gonna pick it up. We're gonna start covering it right before the Smelly and Bortman trial come up. Melly has another motions hearing on the 15th. I think it's the motion for bond on the 15th. It was supposed to be last Friday, but they rescheduled it to the 15th of September. So we'll be bringing that live to you most likely. And if anything happens before then, we'll bring the information to you. So yeah. Shout out to T Sweetie. Shout out to Dre Jones. Shout out to Chicks 1000, aka the Chick 1K. Shout out to Ash Lay. Shout out to Anonymous One. Shout out Jason Follower Christ. Who else? Give y'all shots out real quick here. Shout out to KL1K. Shout out to M Rose. Shout out Music 101. Shout out Audio Crack 22. Shout out to Hypnotic Wheezy. Shout out to Q Ball. Shout out to Queese. Shout out to Kentucky Shannon TV. Shout out Ben Dog Wayne. I'm gonna be coming back to you guys real shortly here. Like, share, comment to this video. Hit the cash app. Follow me on Instagram, Merita1. Follow me on Instagram, Merita1, MERITA1. 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 Follow me on Instagram. Also subscribe to the channel, man. Subscribe to the channel. Is it Merita Boy 1? Yes, Merita Boy 1. I'm sorry, y'all. I'm sorry. My bad. It's Merita Boy 1. MERITABOY with the number 1. MERITABOY with the number 1. Also, man, you want to become a member, man, go to the home screen, click become a member. Let me tell you what becoming a member helps, right? So if you want to support the channel, sometimes I'll be asking for donations, stuff like this. You can also support the channel by becoming a member. It's not that much. It's like $3 or $4 a month, and you're supporting the channel. So if you're not a cash happy type of person, I understand it. Just support the channel by becoming a member. It's exclusive updates that you're going to get. When I get the merch going, you guys are going to get the merch for free. Some of the merch, not the sweaters, but I give you t-shirts for free. Also, I got some exclusive content that I'm going to be doing, and it's only going to be for members. So please, I advise you guys to start to join and become a member. It's only like $3, $4 a month. It's not that much money. And you can support the channel that way if you're not a cash happy type of person. That way you can be contributing. I will also, when it comes to me doing the panels, members are going to get to come up on the panel because I know they invested in the channel. You know what I mean? Like, I'm not just going to be letting anybody come up on the panel. I'm going to keep my panel sacred now. Y'all see how I've been rocking with the panel. It ain't been a lot of people coming up on the panel. So, if I rock with you, you're a member, you know, you'll be able to come up on the panel, man, because I see you with us. You're part of the Squiddy. You're emotional. You invested in this. You know what I'm saying? I need to, you know what I'm saying? I want to be rocking with people who rock with me. You know what I'm saying? So, you know, you feel, you know, this will be your spot, like Cheers. You know what I'm saying? You remember that old show Cheers, you know what I'm saying, where everybody know your name? You know what I'm saying? Go ahead on and become a member. That way your name can be lit up with those nice colors when you make a comment and everybody know, man, you part of the Squiddy. You just ain't some random slide through here. You've been rocking with us. You feel what I'm saying? You feel what I'm saying? So like this video, comment to this video, subscribe to the channel, become a member, follow me on Instagram, MaritaBoy1. And I'll be right back with you guys in a second. It won't be long. Thank you.